This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky.
Pleasant and respectful fools can represent themselves.
Pleasant and respectful fools. We should all aspire to have that on our gravestone.
I don't think you ever want to find yourself in front of a judge, making those kinds of statements about your companies.
If it was insurance would not cover that.
It's not what I want my tax dollars going towards.
Welcome to St. Louis on the Air. I'm Sarah Fensky, in for Elaine Shaw. A horrifying incident that led to what's been called the worst fraternity hazing injury ever in the U.S. has ended with guilty pleas from two of the primary culprits. But both only copped to misdemeanors. Was this a failure by prosecutors? Or all we can expect in cases like this? And 3 Missouri state senators wrongly accused a Kansas man of perpetrating a mass shooting at the Chiefs' Super Bowl victory parade. The man is now suing the lawmakers for defamation. The state attorney general plans to provide their legal defense. Well, who decides if the taxpayers could or should fit the bill? Today is our legal roundtable, and we have some big legal questions and some really good lawyers to help us answer them. And today, that includes Nicole Gorovsky. She's a former prosecutor in both state and federal court. She now practices at Jenkins and Kling PC Attorneys at Law. Nicole, welcome back.
Hi, thanks for having me.
And we're also joined today by Eric Banks. He's a former city councilor for the city of St. Louis, and today an attorney and mediator at Banks Law. Eric, welcome back.
Thank you.
And making his legal roundtable debut today is Jeff Johnson. He is senior counsel at the law firm Shook, Hardy & Bacon. He's in their class actions and appellate practice group. He recently served as Deputy Solicitor General in the Missouri Attorney General's office. He previously clerked for the U.S. Court of Appeals for the 8th Circuit, based here in St. Louis. And before graduating from Harvard Law School, he worked for Chief Justice John Roberts. Quite a resume. Jeff, thank you so much for joining us today.
Thank you so much. It's a pleasure.
And Jeff, I'm especially glad you're with us today because we have a rejected class action lawsuit to talk about. And so before we talk about the fallout from a fraternity hazing nightmare, before we talk about defamation, I think we should talk about this lawsuit. Now, this lawsuit was filed against the city of St. Louis over its 1% earnings tax, and specifically the failure to refund it for people who worked for companies that are based in St. Louis, but who were working remotely for all or part of their workday. This obviously became a big issue in the pandemic. The city began denying requests for refunds of this earnings tax. Attorney Beavis Schock, who's often a panelist on this show, just a fascinating guy, he filed a lawsuit on their behalf. He sought class action status. Now, Beavis and his clients just won a big victory, saying that people are due these refunds, but they didn't win the right to pursue this as a class action. Jeff, on its face, I'm thinking, this is a group that makes sense. These people are all similarly situated. Why would this not end up being a class action lawsuit?
Well, the short answer is that the Missouri Supreme Court has previously decided that under the refund statute that class actions are not allowed. And so there's binding Missouri Supreme Court precedent. So the Eastern Court of Appeals, correctly applied the binding precedent. And what the challengers here are seeking is an equitable exception to the Missouri Supreme Court's ruling. For your listeners, class actions are generally when groups of people who share certain traits and certain injuries get together and say, we all have the same injury. We all there's lots of us. It would waste a lot of the court's time, and to join together to sue a particular defendant. Usually it's not more than one defendant, but they had to meet various characteristic traits under Missouri Rule 5208 or Federal Rule 23A, such as making sure that they all have the same injury. There's too many of them, and that the individuals who stand up to represent the class, that the class representatives in fact represent all the people with all the same claims. So the short answer is that Missouri law just doesn't allow it at the moment, and that what's interesting about the challengers' argument here is that what they say is that the Missouri Rule 5208, is the binding rule as to whether or not you can pursue a class action under Missouri, and it doesn't prohibit us from from doing so under the refund statute. And typically under Missouri rules, a court control over statutes unless statutes specifically single out those rules. And here, the refund statute doesn't do so. So it has been applied for transfer at the Missouri Supreme Court, and we'll have to see if they're interested in taking it.
Okay, so the Missouri Supreme Court still could say, okay, you can handle this as a class action lawsuit. Eric, hearing Jeff explain this, part of the idea with a class action, otherwise you're going to have a lot of little lawsuits that waste a lot of the court's time. Feels like with these earnings tax refunds, that's exactly what we'd be looking at here.
Yes, and in addition to that, the practice, if not the requirement, is that there have to be too many claimants for you to be able to name in your lawsuit. So quite frankly, even if it was 4,000 people, if you knew exactly who those 4,000 people were, then you have to name them as, if you want to have a class action. But in addition to that, I think the problem is, as Jeff said, the refund statute. And there's just really no way to get around that.
Nicole, do you think the Missouri Supreme Court is potentially going to be interested in saying, okay, this refund statute, this doesn't make sense here. Time for us to change this?
I mean, I don't know. It's conceivable that they could look at it and so to be clear, the Eastern District was bound by the prior precedent. They had to follow it. So, but the Supreme Court could look at authority, but they generally follow precedent too. So I'm not seeing it as being likely.
Now, at the same time, this is obviously a loss for Beavis Shock on the class action question, but on the question of whether people can get these refunds, this is a pretty big victory, Jeff.
Yeah, no, Beavis was successful in getting the court to affirm the liability under counts 1 and 2 for his clients, which means that they are going to receive refunds, assuming that the Missouri Supreme Court doesn't overturn that portion of it. And I think what's interesting about this part of the court's opinion is that the court really delves into the issue of whether or not there was a service performed in or rendered in the city of St. Louis. And it's interesting to look at their sort of statutory interpretation under Missouri sort of general canons of statutory interpretation, or how we read statutes. You're supposed to give the plain meaning. Some of that comes from the context of the statute, and oftentimes you also have to end up looking at dictionary definitions if they aren't defined. And so there are lots of dictionary definitions in this particular case, and I think it's interesting in that the statute requires render or perform the service, which is funny because the court doesn't even go to the first definition of render, which is actually to extract fat out of meat and things like that. And they're like, no, we don't have to look at the first definition because that obviously doesn't apply here. And it's interesting to look at how they chose dictionary definitions for render and perform. And for perform, they decided that perform means to give a performance. Which seems inherently circular because they also don't define performance using a dictionary. But maybe in the context of what the court said as to that performance, that the city's earnings tax is to go towards sporting events and musical performances and other things like that, maybe there's a way that you sort of glom on between the two of those and it makes it work. But it's an interesting statutory interpretation case to look at.
So you may have a question about this earnings tax lawsuit or anything else that we talk about today. You can give us a call at 314-382-8255. That's 382-TALK. You can also send us a tweet at STL on air. Nicole, thoughts on that?
Well, I was just going to piggyback off of that and say this was an opinion that only a lawyer could love. It literally went through the definitions of performance, render. I think it even went through a definition of is. I mean, it was
lawyers kill me.
Right. I mean, to talk about things that excite us and bore everyone else, this was an interesting opinion. And, it'll be interesting to see if the Supreme Court agrees.
Yeah, I will say, as I was reading it, my eyes do somewhat glaze over when people start referring to dictionary definitions. As a journalist, that's one of the first things we teach young reporters. Don't get into the dictionary definition of something you're writing about. But it was interesting how they described how the city just completely threw its normal policies out the window when they started getting worried during the pandemic that they were going to face a lot of these refunds. They used to give the refunds. All of a sudden, they're like, yeah, I think we're going to use a different standard on this. It seems like the court didn't look too kindly at that, Eric.
I agree. And as much as I would like to be sympathetic to the city of St. Louis, I think that they are making the wrong decision on this one. There has to be some way that you can give people credit for the time that they're not in the office and not tax them on that. I think it is terribly overreaching that you can have somebody not set foot in the city for a year and then still have to pay earnings tax. That is ridiculous.
Jeff?
Yeah, no. And I think the other thing on this is that the facts in this case obviously help the challengers in that when the pandemic hit, the tax assessor changed how he was going to go about doing refunds. And so that's always a good fact if you're challenging a law and you see, a government agency sort of change its interpretation suddenly based on, outside factors. But I think it also raises lots of fun hypotheticals under this opinion as to, if you're an architect in Omaha and you get to design the next, central library here in St. Louis, does he have to pay the earnings tax under the city's interpretation or not? Has he performed or rendered a service into the city?
These are the big questions, and this is where dictionary definitions fall short.
Well, if we were not to put too fine of a point on it, what about outside counsel that flies in to try a 3-month lawsuit? Are you going to start charging those folks too? Or where does it stop?
Yeah, I think that's a good question. And there is actually a somewhat related, but not totally related lawsuit from the law firm Bryan Cave, Leeton Paisner, where they've now said the city is calculating this totally wrong. This is soaking our partners. If I were the city, I don't know that I would want to have to fight Bryan Cave when Bryan Cave's own earnings are at stake. This is going to be aggressively fought. I want to talk about another ruling affecting local municipalities. This comes from the Missouri Supreme Court, and it comes in a suit filed by Kansas City. The court in this past month actually threw out the results of an election over what it determined was misleading ballot language. This has to do with funding for the Kansas City Police. Voters in this election agreed to raise it from 20% of the general revenue to 25%. Seems reasonably clear-cut, but this ballot language, this became a huge issue. Nicole, how did this get to a point where a court is saying, hey, the people voted on this, we're going to throw out what they voted on?
Yeah, I think probably this litigation should have happened before the election. But I think, I think they have to review the fact that there's a challenge to this misleading language, and the law says they can do it after the election. So, we're dealing with that a lot. What went through my head was the initiative petition for abortion rights and things like that. There's tons of litigation before something like that gets on the ballot over what they are calling ballot candy, I think they call it, and the appropriate language to go on there. And so this is just another example of that. And I do think, when you think about it overall, it's important to make sure that the language that ends up on the ballot is not misleading. And so, I think it's the right thing to do.
Maybe this will stop people from trying to go too far in the future. Jeff, is this a case that you have some insight in, but you want to make clear that you are not speaking on behalf of anyone but yourself here?
That's correct, Sarah. Thank you. So I represent defendants in this case before the Missouri Supreme Court. It was an honor. But the views that I express here are solely my own. And I think that the opinion is sort of interesting. As I actually agree with Nicole that this should have been decided earlier. And in fact, there is a statute to handle what's called ballot summary challenges. It's under 116-190 in the code. And what happens is that after it's certified, you're then supposed to file a petition in Cole County, in the Cole County Circuit Court, and then it gets fast tracked and that gets decided in a very short period of time. So this is all over, well before the election, and the ballots have to get taken care of. And so essentially what has happened here is that until the Dodson 1 case, which was in 2016, the Missouri Supreme Court had never heard an election contest, is what they call it, as to whether or not there was like some issue, a misrepresentation or some misleading ballot language Election contests had otherwise previously been on things like qualifications for election officials. Your classic election contests are things like, a candidate in a local election says, "Oh, the pollsters stopped my people from dropping off my busload of seniors," right? And had that not happened, I would have then won the election.
Yeah.
So that's sort of how sort of I view like the ballot summary versus like election contest sort of view, and it's in two different parts of the Missouri Code, and I think that what the Missouri Supreme Court essentially did is they said, well, we already decided Dotson 1, and then we followed up with Dotson 2, and also a case called Schumeyer versus Kander the same year, and we said that this was okay, and that you could challenge the ballot title after the election. And so because we did that then, at a minimum, we probably need to allow people to challenge this one because they might have like a due process right or a reliance interest, from our previous cases.
Do you think then this decision in 2016, has this opened up Pandora's box and we're just going to see nonstop people trying to argue the refs after the play has already been scored? That's a terrible football analogy. I apologize.
No, so this is actually something that Judge Breckenridge recognized in her dissent, I think, in the Schumeyer case, which was that, she said, when we first decided this case, we did it in like a month. And we felt like we had to step in and do this. But now after having, seen the course of this for over a year in Schumeyer, it took about 10 months or so for the opinion to issue. She said, we shouldn't be allowing people to sandbag the electorate after they've already gone to the polls and voted. And so that was one of her main themes in her dissent in the Schumeyer case. So, a Missouri judge has already said that we shouldn't be doing this. But I think the Missouri Supreme Court has sort of decided that they're going to stay the course on this and allow people to do this afterwards. So it is opening up a Pandora's box, as well as allowing local officials to run these cases in their individual capacities in using taxpayer-funded money like Quentin Lucas did in this case.
And yet here is, again, as sort of Nicole was referencing earlier, Eric, this maybe will help people be honest in these ballot summaries. This is always going to be looming, that the Missouri Supreme Court is willing to throw out your results. It seems like that could get people's attention.
It could, but it couldn't as well. So who knows?
We're talking today to our legal roundtable. That is Eric Banks. We're also talking to Jeff Johnson and Nicole Gorovsky. We need to take a quick break. When we come back, we're going to talk about a defamation case that has split two Republicans in Jefferson City. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha, and the reason I'm in is because today is our legal roundtable. Today we have three expert attorneys helping us make sense of everything involving the judicial system that's been in the news in the past month. That includes Nicole Gorovsky. She's a former prosecutor in both state and federal court. She now practices at Jenkins and Kling, PC. Making his legal roundtable debut today is Jeff Johnson. He's senior counsel with the law firm Shook, Hardy, and Bacon. He works in their class actions and appellate practice group. And we're also joined today by Eric Banks. He's a former city councilor for the city of St. Louis. He's currently an attorney and mediator at Banks Law. So, Eric, a Kansas man has sued 3 state senators from Missouri. They tweeted a photo of this man, Denton Loudermill, claiming he was a, quote, illegal immigrant, which he wasn't. And they suggested he'd been arrested for the mass shooting at the Chiefs Super Bowl parade, which he also had not been. Attorney General Andrew Bailey entered an appearance on behalf of these senators. But that's when things got complicated. Governor Mike Parson said, not so fast. He said Missourians, quote, should not be held liable for legal expenses on judgments due to state senators falsely attacking a private citizen on social media. So, Eric, you've been a city councilor. How does this work? Who decides when the resources of the government become employed to help someone who's doing something like tweeting?
Well, I certainly don't want to give the devil his due, But I have to agree with the Attorney General spokesperson who said that he's the independent Attorney General, unlike the city councilor is appointed by the mayor. And what to be done if there's a difference of opinion is a lot clearer there, because as city councilor, if the mayor wanted me to go in a direction that I didn't think was right, didn't make sense, unethical, illegal, or whatever, if I could not talk him out of it, then I was duty bound to offer my resignation. But with the Attorney General, it's a different set of facts. But the fact remains is Governor Parsons is the top dog in the state of Missouri. He controls the administration. And if he says, no, this is not the type of bill we're going to pay, it sticks.
So that's an interesting thing. As you say, when you were city councilor, you were appointed by the mayor, worked in that job. Here, it's an unusual case because Andrew Bailey was appointed by Governor Parson, but that's not normally how it works. He was appointed by Governor Parson because Eric Schmidt, who had that job, gone somewhere else. So Mike Parson had to fill the vacancy. This is an independent position. It's normally elected by the taxpayer. Does that mean, Jeff, when you were there, that Andrew Bailey does not take his cues from what Governor Parson says he will and will not pay for?
You know, I think when people take the oath of office, they take the oath of office to uphold the Missouri Constitution. And no matter if you are appointed or if you are elected, and I believe the Attorney General is running for election this cycle, then I think that, they feel duty bound to perform the duties of their office, and use their own judgment. Presumably when Governor Parson chose him, that he thought he had the judgment to make the decisions that were good for the people, state of Missouri, for Attorney General. Looks like he might be having second thoughts in this case.
In this case, it does sound like it. So what's the decision here that Andrew Bailey has to make? How does he decide when his office is going to get involved representing public officials who get sued?
Sure. So I think what's a particular issue here between Governor Parson and Attorney General Bailey is something called the State Legal Expense Fund, which is essentially how the state of Missouri funds judgments against it, as well as provides legal services for all of its employees. Also, there are doctors and medical providers who also get state. It's called SLEF, or State Legal Expense Fund coverage, and your more knowledgeable listeners might know that, like, one of the issues that happened for back in the day for Attorney General Webster and for the fraud and other charges arose from the Attorney General, having carte blanche over the State Legal Expense Fund and giving these representations to his friends. So what the statute provides is that the Attorney General is supposed to authorize the payment, and then the Office of Administration is then supposed to pay it. Under the statute, it says that the Office of Administration shall pay the money. So it will be interesting. It's not often that you see, the main administration of the state of Missouri facing off against their attorney, and then doing so maybe in court.
Yeah. So a spokesperson for Andrew Bailey says ultimately the court will decide this issue. Nicole, what's your best guess? Will they be sympathetic to Governor Parson? Will they be sympathetic to Andrew Bailey?
Well, I don't know if that's what it would really come down to in court. In court, it would be, is it defamatory or not? And defamation is, a false statement that's published that causes damage to someone's reputation. I think that's kind of a no-brainer here that, we have defamation. I think, the issue of who's going to pay, whether the state's going to pay for it. I mean, I think a lot of it will come down to whether or not, a court, if it comes to the court system about who's going to pay, thinks that these guys were acting in their, official capacity as members of the state legislature, or were they acting as individuals? If they were acting as individuals, they're not going to get coverage, and they shouldn't. So, it comes down to, social media is, the wild, wild west. And do we think that social media is, an official activity or not? I tend to think not.
We've all seen those disclaimers on Twitter where they say, this tweet does not represent my employer. Can a Missouri senator say that? I mean, really, they're speaking on behalf of themselves. However, they're also speaking on behalf of themselves as a lawmaker to some extent. Jeff, how do you fall on that question?
Yeah, so I think I think recent Supreme Court precedent has helped sort of clear up where we think social media and official duties sort of coexist. In a case called Linke versus Freed, the court essentially took this totality of the circumstances test, where the court's supposed to look at the content, the frequency, like is this person giving or is this person excluding everyone for government announcements that you would ordinarily see? Like, if school's closed, is the school superintendent only tweeting on his personal account? Or is he tweeting off of the official? Does it have all the trappings of the official, school account kind of thing? And so there is more recent precedent in Linke versus Freed, and there's a second case that companioned one that I don't remember the name to. My guess that we'd probably go through and apply this and see whether or not the Missouri state senators are using their social media account as part of their office, or are they doing all dog photos or cat memes?
Eric, I know you have not closely looked at these senators' social media accounts. What's your best guess of whether they were operating in official or personal capacity with these kind of tweets?
Well, the analogy may be incorrect, so pardon me if I am misstating the analogy, but in my humble opinion, this is the functional equivalent of an intentional tort. And if it was insurance would not cover that. So insurance does not cover intentional acts. And I don't think there's anything any more intentional than somebody accusing a Kansan of being an illegal alien and then shooting somebody at the Chiefs. I mean, that's beyond the pale.
That certainly wasn't part of their official duties to go around accusing someone of these acts, much less wrongly accusing someone of these acts. Jeff?
Yeah. So two important points I think that Eric pointed out was the one that this is a Kansan. So he actually brought this case in the District of Kansas. And so Kansas law is going to apply. But then another sort of interesting legal presentation on this is that on April 30th, the Missouri Supreme Court actually granted transfer of a Court of Appeals case that involved whether or not state employees performing their duties in good faith for the SLEF to satisfy the judgments. And in that case, essentially, someone had not defended the case well and had gotten a judgment against them, and then came back to the state legal expense fund and said, "Here, please pay my judgment." And so that's how that case arises, and the Missouri Supreme Court is going to hear that case in the coming months, and it would directly touch on this issue now.
Yeah, to touch on what Eric was saying, just to go back to, I mean, we're lawyers and we love to get in the weeds, but just to go back to what Eric was saying, I mean, the fact that this happened is horrible, and I really do hope that the state doesn't end up covering it. It's not what I want my tax dollars going towards.
Let's talk about another mistake that someone made. Well, a Missouri company was sued by a former employee. David Steele alleged that Johnson Controls, Inc., also known as JCI, retaliated and discriminated against him after he filed a workers' compensation claim. He sought compensatory and punitive damages. JCI, strangely, just never responded to this lawsuit. So the judge ruled in Steele's favor. He awarded him $900,000. Well, some like that will tend to get your attention. That's apparently when the company's general counsel became aware of the case. She moved rapidly to intervene. She filed a motion just 8 days later saying, "Oh, hey, sorry, we forgot to reply." Some of us can probably identify with this poor general counsel filing this motion at this point, way too late. Nicole, did she get a do-over?
Well, so to set aside a default judgment like this, you have to have a meritorious defense, meaning, you have a good, you can make a showing that you would have won the case, and good cause for why you didn't respond. And I think in this case, the general counsel that you just referenced did not really express good cause for why they made the mistake. They kind of said, oh, well, it was sent to the wrong part of our, company, and then it came to me, and then I kind of ignored it because it said workers' comp on it. That is not good cause. And I don't think you ever want to find yourself in front of a judge, making those kinds of statements about your company. So I think the court was fully justified in doing what it did here. The punitive damages is a little, surprising.
That they hold up.
Yes, on a default judgment. But, the court was completely within its authority to do this.
And the court here, just to summarize for people, the court said you do not get a do-over. This stands.
Yes, that's right. It stands.
Well, there's something about this whole thing that goes against the code of the hills, because in my world, if a defendant is late filing an answer, I'll pick up the phone and say, hey, what's going on? Why haven't you answered this? And they'll usually apologize, fall on the sword, and get it done. And then you don't have these, I got you, you didn't file an answer in time. Now, if the attorney proceeds to ignore me, as they have been known to do, and I call it up for a default hearing, and the other side gets notice of that, and they don't show up for the default hearing, well, all bets are off at that point.
So, Eric, why would you do that courtesy of trying to alert them? Like, hey, somebody needs to respond to this. Isn't it easier just to sneak one in, get a big punitive verdict?
No, because it will happen to us someday. It's like drinking and driving. I mean, the only person who has never driven under the influence is somebody who's never had a drink. And it doesn't make it right.
Yeah.
But we're all guilty of it. So I would like for somebody to show a little bit of empathy, if not sympathy, to me if I'm ever caught that way. So heaven forbid it hadn't happened yet, but my day will come.
Yeah.
And
hopefully someone will give you that courtesy
that's right.
call.
Yeah.
I feel like you've earned that good karma. I don't know about the rest of our panelists, Nicole.
As a former prosecutor, I'm going to respectfully disagree with Mr. Banks about we've all had a DUI. I don't think so. But anyway, I think a lot of this falls on what usually happens. I mean, the practice is, even though it does say, you have to show a meritorious defense and good cause, in all practicality, judges generally, if someone comes in 8 days after a default judgment, judges generally do let them open the case up, because most courts and most judges dislike technical rulings that aren't on the merits. They like getting to the merits in cases. And so I think they could have given it short shrift, because that's what typically happens, is that you come in, you say your mea culpa, and the judge kind of lets it go. But, you do have to be prepared for the time when it's not going to happen.
Jeff.
Yeah, and also agreeing with Nicole, since silence is sometime an omission, right? That I think she makes a good point, actually, and it's a point that the concurrence made in this opinion about the punitive damages, which is that the statutes that allow for punitive damages have very specific requirements, like no initial pleading in a civil action shall contain a claim for punitive damages. Right, you have to then seek leave to do so. So it's a little bewildering how you could then award punitive damages, in the initial complaint for under a default judgment that didn't seek leave of court to do so before they filed the complaint.
Do you think we'll see this continue to hold? I imagine there might be an appeal of this ruling. I think it came out of the Missouri Appellate Court.
No, this is the Missouri Supreme Court.
Oh, this is okay. So this is over.
This is over unless they have some ground, some federal rule or law to seek certiorari before the Supreme Court of the United States.
So they have the longest of long shots to get this thing overturned. They're stuck with this $900,000 bill.
Yeah, the court here has about 50 cases out of more than 6,000 filed every year. So it's a long shot.
So, Eric, as you mentioned, there but for the grace of God go any of us. We've all missed deadlines. If you're in the situation of this in-house counsel and you realize how much you screwed up, what's your best move at that point before the judge?
Well, I am not convinced that the arguments that he put forth don't have some merit. That's a mighty big company, and I can see how he would not have notice of it. But he's in charge of handling his own ship. So if he doesn't have the proper managerial controls in there, well, shame on him. I think the right course of action is to ask for forgiveness and throw myself on the mercy of the court. And, Your Honor, I'm sorry this has happened. This is how it's happened. I'm going to ask you to exercise your discretion under the statute because you have a year that you can set aside a default judgment. And I'm going to ask you to partake of that discretion that you have and turn this one aside.
So maybe a little more humility could have served this general counsel better than just sort of the pro forma response.
A whole lot.
We're talking today to our legal roundtable. That is Eric Banks. We're also joined by Jeff Johnson and Nicole Gorovsky. Coming up, the resolution of one of the worst fraternity hazing injuries in history happened right here in Missouri. This is St. Louis on the Air on St. Louis Public Radio. Welcome back to our legal roundtable. I'm Sarah Fensky, in today for Elaine Cha. I'm here with three attorneys who are sharing their insight. Today, for his legal roundtable debut, that's Jeff Johnson, senior counsel at the law firm Shook, Hardy & Bacon, works on class action and appellate in that practice group. Jeff, how's it going so far? You feeling good?
Thank you. It's been great. I appreciate being here.
I feel like Jeff, it seems like he's been doing this his whole life. That's always the sign of a good panelist. We're also joined by Eric Banks, former city councilor for the city of St. Louis, an attorney and mediator at Banks Law. And then also Nicole Gorovsky, a former prosecutor in both state and federal court. She's now at Jenkins and Kling PC. So, Nicole, what's been called the worst fraternity hazing injury ever in the U.S. has ended with guilty pleas from two of the frat brothers accused of sort of triggering it. Ryan Delante of Manchester and Thomas Schultz of Chesterfield were both charged in the incident that left a young pledge brother with a blood alcohol limit of 0.468%. That's 6 times the legal limit in Missouri. The victim was a freshman at Mizzou. He was left with very serious brain damage. But Schultz, one of the brothers, pleaded guilty to a misdemeanor. He was sentenced to probation. And now Delante is pleading guilty to a misdemeanor as part of a deal with prosecutors. This seems like a pretty low-level conviction for such a serious injury. Is justice being served here?
With this, first I should acknowledge that Boone County office is the office I came out of. That's where I used to work. But I do think that these sentences are too light. I think, this is a big deal. This is, one kid apparently told him, you have to drink this bottle of vodka. And another kid, I think, apparently poured beer down his throat. One of the kids I'm calling them kids. One of the guys that was convicted was considered the pledge dad. So basically, I think gave the instructions of what they were supposed to do. And like you said, the BAC ended up 6 times the legal limit for driving. And the young pledge's heart stopped and he suffered brain damage. We do have specific hazing laws in Missouri. They are generally a Class A misdemeanor for hazing in Missouri. But the thing is, if it creates a substantial risk to the life of the student, then it's bumped up to a Class C felony. So to be clear, a misdemeanor has a potential sentence of up to a year, whereas a Class C felony has a potential sentence of 3 to 10 years in prison. So they certainly had a felony here, and so they had that 3 to 10 years in prison available to them. And I can't help thinking that a judge or a prosecutor looks at the student standing in front of them and thinks, this student had so much in front of them, they look like me. I think there's an implicit bias there that they give these people light sentences, whereas if it was, a black man who had committed a lesser crime, I think could end up getting a greater sentence. And it really bothers me. And I've been speaking about this for years because I think the same type of thing happens with child exploitation cases where a judge looks at, someone who they considered an upstanding citizen in the community and gives them a lighter sentence. But this is a very serious crime with a horrible injury, and I think the sentence is too light.
You also have here a victim who I imagine would be sympathetic to the same people who would find these defendants sympathetic. This is also, somebody who looks like a good kid to your jury. Does the prosecutor have to take into account, though, that, okay, a jury's not going to convict these clean-cut young men who can afford expensive lawyers? Is that part of the calculation a prosecutor has to make?
I don't think that we have that knowledge that a jury isn't going to convict. I don't think we've done enough of these cases in Missouri. I think, hazing laws are still relatively new. I think a prosecutor's office, I think that's part of their job is to, do the right thing and see how it plays out.
Eric, Nicole brought up this factor of race here, that this is most likely a white judge. And we've got some nice young men who might well end up being the kind of nice young men who go to law school, had they not hit this bump in the road with a misdemeanor.
Well, I'm not sure it was a white judge. As quiet as it's kept over here on this side of the state, Boone County, Cole County, Boone County does have an African-American judge. And I think she's an associate circuit court judge. And she may have heard this plea if it was originally prosecuted as a misdemeanor. Yeah. So I can't assume that it was a white judge presiding because I know that Boone County has a black judge.
Yeah. Do you share Nicole's fears that these young men are getting away with something they shouldn't have been allowed to get away with?
Yes, it insults my sensitivities. And the idea of implied bias, I can't escape that. And quite frankly, that's one of the reasons why lawyers are required to have 15 hours of continuing legal education credit to keep our law license. And 3 of those credits have to be in the line of ethics, and one of those 3 has to also deal with implicit bias.
So I'm going to talk about another case that more directly involves race. A St. Louis police officer is suing the city over what he says was discrimination, a hostile work environment, and retaliation. Brandon Clark says he was one of just 3 black detectives in a bureau of 26 in the city. When he saw a white officer assaulting a black suspect, he filed an internal affairs complaint. He says his colleagues then targeted him. They told him to trim his beard. They made him cut short his vacation. They even called him a snitch. Nicole, based on what's in the pleadings here, do you think he has a solid case?
Well, I think, they have to show that race was a motivating factor in these actions. And I think the way it's pled, you would tend to believe that. But again, a pleading is just one side of the story, and we have to wait and see what the response is and how it plays out. I do think, it's certainly pled so that the elements are met, but it'll be interesting to see. Certainly, if he's right, what happened to him is absolutely horrible. And the Missouri Human Rights Act is the vehicle for that.
Eric, do you agree? This is, this is somebody who's bringing a case that could see some success.
Yes. The only devil's advocate question that I have is under the Missouri Commission on Human Rights Act and the Equal Employment Opportunity Commission's Title VII and its progeny. Generally, you have to be engaged in a protective activity in order for the retaliation provision to apply. And I always thought that meant reporting it internally or being involved in a lawsuit, an investigation, or something by outsiders. Perhaps he can dovetail, get away with that requirement of filing it because he did file an internal claim. Mm-hmm. Now, whether or not he said that the magic words for him to get the protection as a result of filing internal charge, I'm not sure.
So just filing an internal affairs complaint isn't enough. You'd have to say certain things.
Yeah,
okay.
Yeah, I would suspect that that's the case.
Jeff, any thoughts on this one?
Yeah, no. I'll defer to Eric a little bit on this, but as I remember for these kinds of retaliation cases, typically when someone files the complaint internally, the employer adjudicates it, and then I thought that the MHRA required them to first seek a sue letter from the Missouri Human Rights Commission and or the EEOC first. Okay. And so when they do that review, they will be looking at what he initially claimed in his internal complaint.
Nicole?
Yeah, to be clear, he must have gotten a right to sue letter before filing this petition. But to clarify the retaliation, the way I read the petition, retaliation was a piece of it. I think there was also a direct racial discrimination claim as well. It was kind of, so I think probably purposely pled a little vaguely. So I do think, I think his claim of direct racial discrimination could be the issue here. And like I said, I do think it's properly pled. I think that the elements are there. It's just whether it plays out in the facts, in the pendency of the dispute.
So this may be one we talk about more in the coming months. I also want to make one note on that hazing case we were talking about in Boone County. One of our producers says that it was handled by Judge Kevin Crane. This was a white judge. And again, we did have white defendants in this case.
My old boss.
Your old boss. Okay.
Yeah.
One last ruling I want to get to as we're talking about today. This comes out of the 8th Circuit Court of Appeals. It involves a St. Louis man who wanted to serve as his own lawyer in a criminal case. Lawyers just love it when defendants want to do that. The problem was that Anthony Willis subscribes to the beliefs of the sovereign citizen movement. It's kind of hard to encapsulate what all goes into the sovereign citizen theory, but it basically suggests the U.S. operates illegitimately, that certain laws don't apply. It leads to some very convoluted legal arguments. The FBI says it's a domestic terrorism movement. So this guy, Anthony Willis, wouldn't stop spouting his sovereign citizen theories. The judge revoked his right to represent himself at this trial. Jeff, did the judge make the right call here?
Well, the 8th Circuit said no. I think the rule from U.S. v. Willis is that pleasant and respectful fools can represent themselves.
Pleasant and respectful fools. We should all aspire to have that on our gravestone.
So I mean, you have to feel a little bit for both counsel in these cases because what happens when you have they're basically fraternity hearings, which is your right to represent yourself in court. The judge usually appoints standby counsel for the defendant because oftentimes they do things that are crazy, disruptive, and physically abusive, or yell and shout in court and things like that. And that's when the court typically says, "No, you're done. You're too disruptive." But what the 8th Circuit said is that he was pleasant. He kept spouting his crazy theories. There's an 8th Circuit precedent, I think, called U.S. v. Ward, that says that you are welcome to be an irritating fool in front of the jury of your peers, and you take the risk of doing so.
An irritating fool. I love some of these phrases. This is where the law starts to get very interesting and readable to me. Nicole.
Yeah, so I used to deal with these types of defendants in my prosecution days all the time. We'd have these guys who wouldn't pledge allegiance to the flag if it had the yellow fringe on it. I mean, it got really nutso, which, it can be a little bit fun. But I think this judge may have got confused between, a person wanting to go for jury nullification, which is, trying to argue to the jury that for some reason that isn't related to the law, you should get off, or in fact, even arguing to the jury that they should disregard the law for some reason that they want. And you're not allowed to do that. But not allowing them to represent themselves is a totally different standard. And if the person isn't obstructive and disruptive, meaning impolite and beyond, then you don't, as a judge, have a right to tell them they can't represent themselves.
Yeah, and the 8th Circuit came down pretty hard on this. Jeff, I saw you nodding as Nicole was sort of talking about having to work with some of these types of defendants. Have you had the pleasure?
No, I haven't had the pleasure. I've had the pleasure of reading these transcripts, and I know that the sovereign citizens, as you said, there's a host of things, the fringe on the flag, but I think we do need to give a little bit of credit to the judge. There were both the magistrate judge and the district court judge, because they did try very hard through all the quoted parts of the transcript show, the judges are doing very hard to make sure that they are getting a knowing and voluntary waiver of this guy's right to have other counsel represent himself. And at one point, I think it was the day before the trial, the self-represented defendant said, "Oh, I'm not representing myself." And the judge was like, "What are you talking about? We have been doing this for, weeks now." And he's like, "No, I'm representing the property of Mr. Willis." Or, he's like, "Just like the United States is, in this room, so is Mr. Willis." So it's a tough situation and it's difficult. And sometimes these things get get a little mixed around.
Yeah, sometimes we give judges a hard time on this show, but man, they have to put up with a lot. Jeff Johnson of Shook, Hardy, and Bacon, thank you so much for joining us today.
Thank you.
And Nicole Gorovsky of Jenkins and Kling, thank you.
Thank you.
And Eric Banks of Banks Law, thank you.
It's been a pleasure.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.